Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about strip searches. Cases that should have gone to the Supreme Court of Canada, but didn't. In a case where an individual was first stopped for a driving offense, which turned into an investigation for a firearms offense, which turned into an arrest and an investigation into a drug offense, the individual was taken back into custody by the police and strip searched. They argued at trial that the strip search was unrelated to the investigations that were taking place, was unjustified, and was a violation of their rights. And their application was allowed, and the court ordered that a stay of proceedings be granted on the basis of the fact that their rights were violated in such a demeaning and dehumanizing way. The Court of Appeal, however, disagreed and said that although a strip search is degrading and dehumanizing and was unnecessary and unconstitutional in those circumstances, the temporal and contextual factors that the strip search was conducted in were far enough removed from the other type of investigation that it didn't warrant the remedy of a stay of proceedings, and granted a lesser remedy as a result of this. And this case raises very important issues. What is the remedy in the context of a police investigation and a charter application for a strip search? We've seen the Supreme Court of Canada previously order $5,000 in damages under the charter for a civil suit as a result of an unconstitutional strip search. But what about in the context of a criminal case where somebody's applying for a stay of proceedings or some other remedy? What is the test to determine what remedy is appropriate where somebody's personal dignity is violated to such a degree? And how does the temporal relationship between the arrest and the other investigation and the strip search have any role to play in whether charges should be thrown out? Even though it may be temporally separated from the original reason for the arrest or temporally separated from the events that occurred, it still has the most significant impact on somebody psychologically of anything that the police really can do in that context. And so isn't that how we should be analyzing this issue? Where it comes to your basic human dignity, it's hard to conceive of a remedy, much like the Supreme Court of Canada has already said in the context of delay to your trial, that it's difficult to conceive of any remedy that would truly be appropriate for a violation of those rights. If it's a reduction in sentence, you don't get a remedy for a violation of your rights if you're found not guilty of the offenses. If it's some sort of exclusion of evidence, you don't get a remedy if nothing is found. This doesn't seem to sit well, and it would have been nice to see the Supreme Court of Canada discuss why a lesser remedy than a stay of proceedings would ever be warranted in the context of a strip search, especially because these happen every single day across this country, and people have a significant privacy right and expectation, and an expectation that if the police go too far and violate their dignity in that way, they're going to get an appropriate remedy. Unfortunately, it's going to take another case and another unconstitutional strip search before the Supreme Court of Canada has the opportunity to revisit whether the current remedy structure is really sufficient to attempt to ameliorate the effects of this breach. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.